devices this time, unlike the last time we had a session. So yeah, as rightly introduced, I'm a practicing advocate. My name is Sanskruti Mahale. I'm a practicing advocate based out of Pune and Bombay. I have regular appearances through various, like before various forums in Pune and Bombay High Court as well, and a few forums in Bombay. So without further ado, I would like to present my screen. Right. So is the PPT visible?
Yes, ma'am.
Perfect. Okay. Okay. So today's session is about the negotiation skills. So I've named it Art and Science of Negotiation. So let's begin with something. Can everyone just tell me how negotiation is used in daily life or professional life? Like, in short, how do you use negotiation? How often do you think you use negotiation in your daily life?
Ma'am, negotiation can be used in daily life, uh, such as buying stuffs or locking a deal.
Right. So it's a very important skill to lawyers, right? If you ask a first generation lawyer as to what a lawyer does, he'll tell you a courtroom scene is there and a lawyer argues and presents its case before the judge. However, someone's saying especially with siblings, okay, Anuradha, okay. Yeah. So right now we are here to learn negotiations, of course, as a daily life skill too, but more prominently, negotiation skills to be used while acting as a professional, as lawyers. We all are lawyers or law students, and we all need this skill very importantly. Now, negotiations we do in daily life. Sabzi lane se leke, we do it on table, dealing or negotiating with a client. So the band is broad, right? The spectrum is broad, but we all like there are different models used internationally wherein negotiations are done in a strategic manner, right? There is a flow to the negotiations. And yeah, so we will learn about a few models here: Harvard model, Patna model, Vatna model. So there are a few models where are which are included in the session, and let's begin with it. So what we'll cover today, importantly, we'll be covering why negotiation is a core lawyering skill. We'll also cover the Harvard negotiation model. We'll cover SOPA. We'll cover practical tactics and tricks which are used in negotiations. We'll study positional versus principal bargaining. We'll study BATNA and VATNA. We'll study RADPAC, and we'll have a few exercises that will go along the session, right? So, like I said, the first year lawyer or law graduate might say that lawyers do courtroom arguments. However, when you ask a seasoned lawyer, a lawyer who has been in the profession for quite a lot of years, will tell you what they negotiate at tables, right? They do settlements, they do conferences, they do calls with the opposing counsels, and they often redraft and draft clauses of agreement. So all of this includes negotiation, and Section 89, which is promoted by the courts as well of CPC, wherein judicial settlements, arbitrations, and mediation conciliation methodology is used other than going for trial, right? So building this skill is essential, and we'll study a few models today, right? Like I said, where all negotiation shows up in legal practice. It shows up in client counseling, settlement talks, contracts, plea bargaining, fee engagement when you're arguing with the client for fees. There also, it is important how you negotiate, right? I'll give you a practical tip way forward in the session, right? So the framework that every negotiator should know, right? Now we start with positional versus principal bargaining, right? And what it is. So positional bargaining, you can consider it as a tug of war, right? Wherein parties will have fixed demands and they'll not be able to reach at a midpoint, right? अभी very simple example if you take कि you go to FC road, right? बहुत लड़कियां गए होगी FC road पे, there might be guys accompanying their girlfriends, friends or mothers, right? So वहाँ पे you go and then you ask कि भैया suppose ये t-shirt कितने का है, and he tells you 500 rupees. And then the negotiation, someone will start from 50 rupees. Now these are two extremes, right? 50 rupees, 500 rupees. And this is what is positional bargaining, wherein parties take out fixed demands and they are not able to reach a midpoint, right? Stretch karke 500 ka, you do 100, you do 150, and he'll come down to 350. However, either there is a disagreement between the parties and the or the figure is argued upon, right? Without looking after the interpersonal relations, the relationship with the person. And often it is a low trust setting, right? And it is considered as a tug of war. Like whatever one side gains, the other side is assumed to lose. Okay. Now, in contrast, what is a principled negotiation, right? Principled bargaining or principled negotiations. So instead of arguing from fixed demands, ki 50 rupees, 500 rupees, both sides dig beneath their stated position to find underlying interests, right? तो यहाँ पे होता क्या है in I'll use both the language here, Hindi and English, both. Okay, so this is the whole method of principal bargaining is developed by Harvard. Okay, and it separates people from problem. Right, it looks at a deal in a different manner rather than just arguing on a price point or fixed demand. Right. तो यहाँ पे suppose I'm again FC road, same example I keep so that we all relate to. Right, I tell that भैया कि भैया मुझे टॉप बहुत अच्छी लगी, आप प्लीज 200 में दे दो. राइट, he'll tell me मैम आप पे अच्छा भी दिख रहा है ये, आप 300 रुपए में लेके जाओ. Right, herein you are not only talking about the price point or the demand as to why that fixed price, but you are talking about other things, right? Other criterias, other objectives are being insisted, right? You can also consider this in your legal profession while you are negotiating with a client for fees, right? And if you say ki 50,000 rupees is a reasonable fee, but the client thinks that 20,000 or 30,000 is a reasonable fee, if you hold on to a specific number, there is certain times deal hoga nahi hoga is a later aspect, but there'll be resentments, there'll be problems with your interpersonal relationship, or shayad wo client kabhi aapke paas वापस आए ना, right? Because you are just stuck holding on to 50,000 rupees. But if you tell the client कि sir 30,000 तो मेरा expense होने वाला है, these are the expenses, and you try to explain or negotiate deviating from the figure, then that bargain can reach its finality, right? And your interpersonal relationships also stay good. So the principal bargaining is a whole model developed by Harvard, And these are the essential principles of Harvard negotiation model, right? So what does it say? It says that you have to separate the people from the problem. What does that mean? You have to be soft on the person, like I said, and hard on the issue, right? So you have to attack the problem. You are not fighting with your client, or I'm not fighting with the FC road wala bhaiya ki how he should give me in 50 rupees, or how the client should pay me 50,000 rupees. Herein, you're not attacking the problem. You are trying to reach a conclusion, right? You're trying to close a deal. So you have to separate people from the problem, and you have to. So generally, most negotiations will go bad because there are disagreement over terms, and there are some personal conflicts that happen, right? So you have to separate and try to deviate from a fixed demand, and explain as to how what you are asking for is reasonable, and you have to also try to understand what the other person is saying, right? The second is focus on interests, not the position. So a position is what someone says they want, right? And interest is why, right? If you are asking for 50,000 as your fees for a matter, it is not about that fixed price. It is about why are you asking it and how is it justified, right? So you have to ask why has a party demanded what they have demanded, right? So like I said, you will explain that 30,000 is your expense, and your other charges, and then filing charges, government charges. So these all things, when you explain, you are creating a why it is a reasonable ask or a fair ask, okay? Or while you're negotiating with that FC road guy, you can say that the quality is not up to the mark, and that this is a fair price for the quality that that person is providing, right? The third is invent options for mutual gain, right? So it is like a pie. You have to brainstorm before you decide, and widen your pie, as in you argue over how to split it, right? So in a way, you have to, like I said earlier, you have to come to a consensus that when you explain that person, he'll say, okay, 30,000 is your expenses, 40,000 we close the deal. So that is how you invent options which will be mutual gain. So 30,000 pe wo stuck tha. You were at 50,000. You are also getting above what he had asked. And he is also convinced as to why you were asking a certain figure, whereby you try to reach a mutual gain. Okay. And then the fourth criteria is insist on objective criteria. Anchor terms to market rate, statute, precedent, or an independent valuation, not who has more bargaining muscle, right? If you stay with that same logic that I am the lawyer, I decide my fees, 50,000, if I'm saying it is 50,000, then certain times it may lead to disagreements and ruining your interpersonal relationship. But if you explain as to, जैसे मैंने पहले बोला कि ये charges है, वो charges है, in that you set out different criterias, and then you don't show a bargaining muscle, like I've written in the slide. You don't show that, oh, I am the lawyer, I decide my terms. No, wherein you keep your interpersonal relationship, but also reach at a conclusion. That's what the Harvard negotiation model says. Okay. So you have to negotiate the problem and not the person. And these four pillars are developed by Fisher and Uri, okay, from their book Getting to Yes. Okay, so that's the name of the book, Getting to Yes, in which the entire Harvard negotiation model has been explained. Okay, now if do you guys want more understanding on this topic, we can dive in an example. Just let me know, or else I move forward. Just type it in the chat box whether you guys want more understanding. I can explain. Okay, I think we can move on. Right. Okay. So let's move on. Anyways, we are late. Right. So yeah, this is again the same chart: people, interests, options, and criteria. Yeah. Okay. So now we come to BATNA. Does Harvard negotiation model differ from traditional positional bargaining in legal negotiations? Okay. Okay. So positional bargaining and Harvard model are entirely different things. In positional modeling, you focus, like I said earlier, you focus only on your fixated demands, right? I have quoted 50,000, my client is telling me 30,000, and both are unable to reach a mutual consensus, right? I am not ready to budge down my figure. That person is not ready to r- raise his figure of 30,000, and then either a negotiation is not possible at all, or the relationships is strained. So kal ko we say that maybe the person, the client, agreed for 50,000, but he's upset about the whole deal. He feel like a tug of war. It is a loss for him, right? So win for me is a loss for someone else or the person opposite to me. That is positional bargaining, right? It is like a tug of war. One wins at the cost of another losing, right? However, in Harvard model, that is the principal bargaining model, they are exactly same. Okay, principal bargaining and Harvard model, they're exactly the same models. In this, it is a mutual interest is met, right? So I explain the client as to why 50,000 is just justifiable. I tell that the government charges are so and so, the challans are so and so, the filing charges are so and so, the traveling expense is so and then this is my fees, and that is why it is reasonable. The client also better understands, rather than just me telling how 50,000 only and not explaining as to why it is justifiable. In this deal, you reach a consensus. Okay, the client might say, okay, ma'am, can you please do it at 45,000 or 40,000? And then you also explain, or once the client is convinced as to why 50,000 is a fair ask, you go ahead with the deal. So that is the difference between your Harvard model and your positional bargaining. Okay, in positional bargaining, either the deal never happens, the interpersonal relationship is ruined, or it is win of one at the cost of another. Okay, so at the loss of another, one person wins. It's like a tug of war. So that's the explanation, Simran. Okay, now we move on to BATNA. Okay, BATNA is the best alternative to a negotiated agreement. Okay, so it is actually what you will do if this negotiation fails, and not what you'd like to do, right? So it is not your ideal outcome. So 50,000, like I said, that is my ideal outcome. I want 50,000. But if not 50,000, I have to decide my BATNA. BATNA is a best alternative to a negotiated agreement. अगर मुझे 50,000 नहीं मिलते हैं, तो I am happy getting 45,000, right? So that 45,000 is my BATNA. It is not my ideal outcome. 50,000 was my ideal outcome. And it is not even the best case scenario. But अगर मैं चाहती हूँ कि ये deal drop ना हो, then I should know what my BATNA is. That अगर मुझे 45,000 भी मिलते हैं इस deal से, तो it is my best alternative. 50,000 नहीं मिलते, तो 45,000 is my best alternative. That you have to figure before you sit for an agreement or for a negotiation or with a client meeting. कहीं भी हो, whatever is the uh, circumstance, you should know your BATNA. You should be prepared about the BATNA before you sit at the table, right? So why it matters for lawyers? You never accept a deal worse than your BATNA. Okay. And and never reject one better than it. अगर मुझे client 47,000 दे देता है, so I will not reject that, right? 45,000 is my BATNA, 47,000 मिल रहा है, I am happy. Okay, a strong BATNA lets you negotiate calmly. If I don't know what my best alternative is, my position at the table fluctuates, right? सामने वाला will tell me, नहीं नहीं मैडम आप कुछ भी बोल रहे हो, 30,000 ही लगते हैं इस चीज के लिए. But if I don't know that my BATNA is 45,000, I might get convinced or try to close a deal at 40,000. कि अच्छा ठीक है sir, 40,000, right? But no, when I know my BATNA well in advance, I will have a more calm and composed deal negotiation at the table, okay? And I'll not be desperate for the deal. He'll say 30,000, I'll let him say 30,000. I will not close my deal, right? Wherein a weak BATNA means you improve it first or you negotiate from a position or forced urgency, okay? Now never reveal your BATNA to the opposing counsel. अगर मैंने पहले ही बोल दिया, मैंने बोला 50,000, उसने बोला 30,000, मैंने बोला 45,000, so he knows that I'm negotiating. So you don't tell your BATNA at first. You keep it to yourself. You have claimed X amount. You know your BATNA. You will not reveal it immediately. You'll listen to all the offers and counter offers, and then choose a deal that is your BATNA or anything over and above your BATNA. Okay, so for 45,000 या 45,000 से एक रुपए भी ऊपर हो, so that is my best alternative and I'll choose it. Okay. So how do you build your BATNA, right? You will list every alternative that you have before going for a meeting, before you meet a person, right? Now as lawyers, I'll talk about meeting the client, okay? So wherever you are going, right? So you will first list every alternative that is possible, right? So first would be trial. अगर ट्रायल को 50,000 लगते हैं तो आर्बिट्रेशन को कितने पैसे लगने वाले हैं, या फिर इफ आई फील कि ये दोनों भी मेरे are not profiting to me, I will just walk away, okay? या फिर there'll be a different person, I might delegate this work to some junior of mine, right? So in this case, you know every alternate that you have possible on the case, right? अगर वो मुझे 30,000 बोल रहा है, and if I want to save the relationship, I might just give it to some junior, or I will find a way out that is possible, okay? चाहे वो settlement talks हो, arbitration हो, okay? Whatever is possible, whatever is the alternative that fits that, I can only accommodate his request if I know what all alternatives are possible, right? Whatever alternates are available with me. Then you have to value each one honestly. What does that mean? Attach a real number or outcome to each. So like I said, you have to know ट्रायल का कॉस्ट इतना लगेगा, आर्बिट्रेशन का इतना लगेगा, इफ आई वॉक अवे तो मुझे को कुछ भी नहीं मिल रहा है, ₹0 फॉर मी. So that is how you attach a number, a figure to each alternative that is possible. Then you pick the single best one. This is your BATNA, right? 45,000 I said, that is your BATNA. And you don't negotiate any further, okay? And you have to keep improving it. If you feel that samne wala is only offering you 45,000, you might say, oh, 47,000 is my deal number, okay? So you can improve your BATNA during the talks or during the conversation as well, but you never go below the BATNA, right? So you have to know that this is my break even. Like I will not be able to pull off work below this particular level, okay? So that is your BATNA. Now what is a BATNA? Okay, so BATNA is kind of worst alternative to a negotiated agreement, okay? And it's basically the worst realistic outcome without a deal, and it is used for honest. Just allow me a minute, I'm getting an important call, please, I'm so sorry. So sorry for that. Yeah. Okay. So Vatna, what is a Vatna? Again, Vatna is your worst alternative to a negotiated agreement. Okay. And this is like, it is a worst realistic outcome without a deal, and it is used for honest risk disclosure. So when you are dealing with a client, right, be it about a case, you will tell him the best case scenario, that the order will be in your favor, or we get relief, right? And worst also, whatever worst could happen also, you have to tell your client, so that you just don't build a rosy picture कि ये हो जाएगा वो हो जाएगा केस जीत लेंगे. No, you have to tell the worst possible outcome as well. Why? Because later on the client will blame you that you did not ever disclose about a worst possible outcome. So presenting only the BATNA risks over optimism. Presenting only the BATNA will also risk a panic settlement, right? Now, in this case, I will keep my screen shared. Okay, I was not audible. Okay. Yeah. So Vatna, again, I'll repeat. Vatna is the worst realistic outcome without a deal. Okay. It is basically worst alternate to a negotiated agreement, right? And why presenting both Vatna and Vatna is essential. So when you are, so let's take an example that there is a client, okay, say Sahil. Sahil is your client, and Sahil wants to sell a flat to Sharanya. Okay. Sahil and Sharanya finalize a deal. They have a registration date. And right before the registration, Sharanya discovers that Sahil's flat has leakage issues, has cracks. Okay. And now she feels cheated, right? She feels that the deal was reached, and she was not aware of the leakages and the cracks. That's why she goes and tells Sahil that either you give me a 8 lakh rupees off from the entire deal, or the deal is called off. Okay. Now Sahil, who is trying to buy another flat, right, needs this money, and he wants to end up a deal that he wants to say he wants to buy a flat in Kothur, okay, and his original flat that he's selling to Sharanya is at Law College Road, okay. Now he wants to close a deal at Kothur as well, but 8 lakh discount is a big or a huge amount for Sahil. Now, as we have studied principal negotiation, we have studied Harvard model, he would ask Sharanya as to how do you justify 8 lakh rupees discount? Is it a resale? Whenever she sells off that flat, she'll get a lesser amount. Is it a compensation for that? Is it the cost for repair work? Okay. So he will try to analyze that, right? Now she knows that the repair cost is 3 lakhs, and she is also interested in buying that flat that Sahil is selling, right? So here, Batna and Vatna. Now Batna for Sahil is, suppose 3 lakh discount kar diya, so it is a fair deal for him. And worst case, Vatna is that the deal entirely collapses. Now, if the deal with Sharanya collapses, the deal that he is making at Kothur also gets prolonged, right? So that is the worst alternative to a negotiated agreement, that the deal is collapsed. And the best is, 3 lakh rupee discount usne de diya, is the best case scenario, okay? So as a lawyer, it is my job to tell Sahil, see, this is your Batna, this is your Vatna. And why I have to tell both of the things? Because you have to show the client a full range of the possible outcomes. It is like an informed consent, and it later on protects you as a lawyer from the client claiming that you showed them a rosy picture or it was over optimism. Okay. But if you only show Vatna कि अरे ये डील अगर निकल गया हाथ से तो तेरा कोथरूड का फ्लैट होगा ही नहीं, तो ही माइट जस्ट अग्री कि ठीक है 8 लाख रुपए डिस्काउंट दे दो या 5 लाख रुपए डिस्काउंट दे दो. So that is not, so that will lead to a panic selling, right? So you don't do that. You have both Batna and Vatna to the client, so that the client knows what range to play between, or what are the outcomes that are possible from a deal. Okay. Now comes ZOPA, right? So that is a zone of possible agreement. It is a overlap between one side will accept and what the other side will offer. Okay. So suppose the seller's minimum value is 80 lakhs. Ki I will not sell below 80 lakhs. Okay. And the buyer's maximum price is 95 lakhs. Ki मैं 95 lakh के ऊपर I cannot buy. Right? So 80 lakhs to 95 lakhs is the ZOPA. That is anywhere between this range, the deal is possible. Okay, between this range. But had this been reverse, had the seller's minimum been 95 lakhs and the buyer's maximum been 80 lakhs, no deal was possible because there is no ZOPA, right? There is no convergence of interest. There is no range that can be played between, right? This deal will never come to an outcome, okay? Unless we'll study it further, that few things are offered so that the buyer kind of improves upon the budget or seller kind of reduces upon the budget, okay? That is the further course of discussion. But ZOPA exists only when there is a range, okay? So anywhere between the range, the deal can happen, okay? And when there is no ZOPA, no deal is possible on price alone. The uh, the like the fix or a change of scope will happen only when there is addition or removal of terms. Kal ko suppose as a seller, I tell the buyer that see, I am expecting 95 lakhs, but ठीक है, I will give you a payment flexibility, right? सो द बायर माइट कंसिडर ठीक है बाबा मुझे पेमेंट फ्लेक्सिबिलिटी मिल रहा है या फिर आई टेल हिम कि ओके आई विल गिव यू अ सेमी फर्निश्ड अपार्टमेंट सो अगेन द बायर माइट थिंक कि मुझे इंटीरियर करने में इतना खर्चा तो लग ही जाता तो ठीक है आई एम गेटिंग अ सेमी फर्निश्ड अपार्टमेंट सो अदर देन द वैल्यू इफ देर आर सम चेंजेस इन टर्म्स नॉन मॉनेटरी वैल्यू कुछ मिल रहा हो या फिर टाइमलाइंस में कंसेशन मिल रहा हो देन द डील कैन स्टिल स्ट्राइक इवन इफ देयर इज नो ZOPA. Okay, rather than repeating the same offer, like the client the seller saying that oh 95 lakhs and the buyer saying 80 lakhs. This is just a repetition. It will never reach a conclusion or a agreement, right? For that there might be some alterations with respect to timelines, terms, or non-monetary value things which can make the agreement reach its finality. Okay, so that was about ZOPA. Okay, right. So this is a practice session. I believe we are short of time to take this. We move ahead. Now we have a RADPAC theory. Okay, so it is a 6-stage negotiation process. Okay, and it is basically a very practical usage of how to build negotiation from scratch. Okay, so it starts with 1R, that is RAPO. So before you directly jump onto the price point or what the deal is, you try to build a RAPO, right? And we do use this in our real life scenario. Like when you're going for an interview, you will study about the company, or if you know the interviewer, you will study about his background. Why do you do that? To build a rapport with that person, right? So when you are, suppose, say Amazon is your client, okay, suppose. Now, when you know what Amazon deals with, you can build a rapport and talk with that person. But if you don't know what Amazon does absolutely, and you just end up at the meeting, you'll not have a leverage. So to have a rapport, you need to do some background work as well and try to build a rapport with the client, okay? Now, analysis. You have to diagnose what the interests are, what the priorities are, and what are the constraints on both sides. At times, there are clients who will say, Madam, fees kitna bhi lagne do, but case to hame hi jeetna hai. Now you know that the interest is winning. Okay. At times, the client is not concerned about what he's kal ko shayad he is fighting for a land जो उतने पैसे का भी नहीं हो, but his interest is winning, and he might have other interests that are not monetary, right? So इसीलिए you have to know what the interests of the client are, what are the priorities of the client, and convince the client what to do. Okay. Then you have to debate what. So what are the differences, right? You have to test the assumptions, ask hard questions. At times the client might be under pretext of some assumptions, okay, या फिर किसी और ने उसको कुछ लीगल ओपिनियन दिया हो या कुछ ओपिनियन दिया हो. वी ऑल नो रिलेटिव्स ओपिनियन देते रहते हैं, अरे ऐसे नहीं ऐसे हो जाएगा, वैसे नहीं वैसे हो जाएगा. सो यू हैव टू debate about those and help the client understand better. You have to analyze and then explain what the outcomes are, how to go about a certain thing. Okay. Then you have to propose. You have to put concrete conditional offers on the table, that if you do X, we do Y, right? Then we have to agree, like bargain towards a package that both sides accept. Like I said earlier, that when you were quoting, I was quoting 50,000 and the client was quoting 30,000. We bargained towards a package that both sides can accept. We close at 45,000 because that was my partner, right? And then while closing, you confirm terms in writing. Never ever have just a verbal conversation with the client and think that that will be followed. No, you have to have the terms in writing. No deal is done until it's documented, right? We all are lawyers. We all know that paper is the proof, okay? Or your digital media as well, but you have to have it in writing. So yeah, so underneath there is a practical tip that most negotiators rush from rapport straight to propose, right? They'll talk thoda bahut and then directly propose what the deal is. But analysis, debate, when you know what the client wants, when you know his interests, when you know his constraints, you will have a better negotiation power, right? कल को you might be thinking 50,000 is the fees, पर the client के लिए सिर्फ winning is important, only winning is important. The client doesn't care about what the fees is. So you'll know that only if you go to the analysis step and you try to figure out what the interests of the client are. If you skip that step, you skip that opportunity. Okay. So this was about Rat Pack. Now this is kind of all 6 frameworks side by side, right? So it is like a revision. Okay. Principal bargaining. How should we argue? Okay, what the answer to the question is, negotiate on merits instead of willpower or ego. So you can't keep an ego, like I said, that I am the lawyer, I decide my terms. You can do that, of course, at a later stage of your life, but till then, we follow what is being written here. Okay. Then the Harvard model, what should we focus on? We should focus on so basically you should structure any negotiation around people, interests, option, and criteria. Okay, I think now you understand all these 4 terms little better. Okay, so that is Harvard model. Badna is what happens if we don't agree. So what is the best case if we don't agree, right? So best case is set your walk away floor and negotiate with confidence. If you know that your Badna is 45,000 and you cannot reduce a penny uske niche, so you have to simply state 45,000 and just walk away, right? So that is your best case scenario. What is a Vatna? Vatna, what happens if we don't agree? What is the worst case? So give clients an honest risk disclosure and informed consent. Ki if you don't file this case or if you don't take up this matter, these things are at stake. That is how you convince your client that the worst that can happen is this. Okay. Then Zopa. Zopa means, is a deal even possible, right? So you have to identify the zone of possible agreement, right? Then Rad Pack. What do we do? In what order we do, right? So there was a clear-cut order that was explained as to rapport, analysis, debate, propose, and agree and close. Okay. So you have to run the actual meeting in this step-by-step analysis. Okay. Start to close. Then you have so practical tactics and tricks that work. Okay. So the first is anchoring. Am I clear till here? Should I move forward? Are there any questions? Do you want a break? Kuch bhi. Just let me know. Everything is fine till this point? Okay, let's move on. So what are the practical tactics and tricks? Now ये सब जो पढ़ा हमने वो कहीं कहीं bookish भी था, but with practical usage of course. So we will move on to what are the practical tactics and tricks that work. Okay. Number one is anchoring, which is make the first reasonable offer. Okay. It will always shape where the final number lands and why I will tell you this. Back to the FC Road example. 500 रुपए उसने मुझे कहा था. He also knew 500 is not fair. And when I say 100, that or 50 rupees, that is also not fair. अगर वो मुझे खुद से ही चला के बोलता मैम 350 rupees and I would have said भैया 250 rupees, तो there is a reasonable offer, right? जिसमें you can bargain. But when there is 550, it is poles apart. You cannot negotiate that kind of agreement, right? So you have to make first offer only reasonable. ऐसे नहीं है कि तुम client को बोलते वक्त 50,000 fees if you are expecting, you tell 1 lakh rupees, okay, and then expect 50,000 per negotiation होगा. No, you have to be reasonable with the court. Maybe you tell 60,000, maybe you tell 70,000, not even 70. Honestly, you tell 60, 65,000, wherein you come down to 45 your batna or 50,000 if you get it. That is your best case scenario. Okay, so your offer should be reasonable. कल को 1 lakh सुन के the client will just decline the call. He might never come back for even listening to why you are justifying a figure. So you have to make first offer as the reasonable offer because it will shape the final number that you land on. Okay. Then the second is deliberate pause, right? So after an offer, stay silent. बहुत ज्यादा yes, I will provide with the PPT. Yeah. Okay. So when there is an offer, you have to be calm. I told you you have to analyze your batna first. So अगर वो 30,000 बोल भी दे, you have to stay calm. You should not immediately react कि ओ 30,000 कैसे, नहीं 30,000 तो होगा ही नहीं, max I can do this. Don't do anything. You know your batna. We have learned you have to hold your calm, right, at your batna. So you have to take a deliberate pause. Most people will try to fill in this silence, but you don't have to be that person. Okay. You have to stay silent and wait for talks and counter talks, offers and counter offers. Okay. Then mirroring. Repeat the last 2-3 words the other side said as a question. It invites them to explain further and it reveals interest, right? So just a second. Okay. Sorry, my okay, yeah. So mirroring. Sorry, I just lost my this thing. Okay. So mirroring kya hai? Repeat the last 2-3 words the other side said as a question. It invites them to explain further and reveal interest, right? Suppose while you are making a deal, okay, वो flat वाला deal, साहिल शरण्या, ठीक है, and Sahil on call tells ki, are you trying to compensate for a resale value price, right? ये जब उसने कहा था, तो Sharan again say a resale value price, as in what do you mean, right? Then the person will have to explain further, and that's where you go in a more powerful position, right? Because you are the one asking questions. So the question gets questioned, okay? And you don't end up answering, oh, no, I was not trying to compensate for my resale value, and over explaining what that person is saying. So if you think that you can mirror a particular question just to be in a powerful spot, you should do it, okay? Then calibrated questions. Ask, how am I supposed to do that? Right? कल को when you quote a fee of 50,000, the client says 30,000, you can ask him, ki, sir or ma'am, how am I supposed to do that? Instead of a no. Let that person explain as to why it is reasonable for him to ask 30,000. Okay. Yashika Tiwari, can you please mute yourself? Yashika Tiwari. Yeah, thank you. Okay. So you are supposed to ask questions rather than saying no, because let that person explain as to why that person is saying so. You don't have to jump to conclusions or over explain yourself. Okay. Then labeling emotions. Okay. So, right. So rather than saying, oh, you have an urgency, right? You can say, it seems like the timeline is a real concern for you. I have explained it in the example. Now, while you analyze, RADPAC में जो analysis था अपना RAPO के बाद, right? You analyze that urgency is the interest of the client, right? But if you say that to him directly, that, oh, you have urgency, he will know what you are trying to negotiate at, right? Instead of saying that particular word or particular emotion, you can frame it in a different way, that it seems that timeline is a real concern for you, sir. So what we can do is XYZ alternatives you give, okay? So you don't label the emotion, you say it in a different manner, okay? Then is bracketing. You propose a range and not a number to test the other side's reaction before committing, right? So you can say that, oh, sir, ये 40 से 50,000 में हो जाएगा, right? So that is your bracketing. Rather than fixating at a particular point, no, 50,000, you give a bracket. So that person knows that min max iske beach he has to decide. Okay, so that is the bracketing. So these are a few tricks that you can use in the negotiation. Okay, anchoring, the deliberate pause, mirroring, calibrated question, labeling emotions, and bracketing. If there are any questions in this regard, please let me know. Okay, let's take a quick question. I want to see how many people are attentive. Tell me one tactic that you have used and one tactic that you've not used. Chat box. Quickly. Tell me any one trick out of this or tactic out of this that you guys have used and one that you guys have not used. You have to tell me what you have used and what you have not used. Okay. Sonal Sharma is saying mirroring. She's used mirroring or not used mirroring, not sure. Okay, use labeling emotions, not tried deliberated pause. Okay, anchoring and deliberated pause. Propose a range. Good. Okay, Ritesh Sharma has used a lot of tricks. Okay, I have tried deliberated pause too. Okay, Sonal Sharma. Yeah, labeling emotion, Nikhil. Okay. Great. Okay. I know that everyone is following with the session. Okay, great. Let's move on to the next slide. What are the common mistakes that lawyers do and that lawyers should avoid? Okay. So first is negotiating without a partner. Absolutely don't ever do it. You should know what your partner is, so that you are always at a powerful position, and you know that you can't go down or go below this particular alternative. Okay. So negotiating without a partner is a common mistake. Second, arguing the client's position, not their interest, right? So fighting over the demand instead of actually driving it, washes around back and forth, right? Kal ko if जो example again, Sahil and Sharanya, okay, 8 lakh rupees ka discount. If I keep saying that no, 8 lakh ही discount करो, okay, and if my client Sahil keeps saying no, 8 lakh is not possible, rather than asking ki, why do you want an 8 lakh discount, what are you going to do with that 8 lakh discount, is it for repair work, what is it for, without doing the without negotiating on the interest and only negotiating on the position, at times the deal is not made. Okay, so you have to try different ways and not just revolve around the figure and not reach a finality. Okay, then skipping the writing up step, like I said, verbal understanding can go south anytime. Okay, so you should have things in writing. Until the terms are in writing, you really cannot rely upon them during the further course of uh, the agreement. Okay, then treating the first offer as final. The first number is an anchor. Okay, so Jabibi, like I said, FC Road, when he said 500, he knows that I will give him a counter offer and negotiate. When I said 50 rupees, I know he will negotiate and give me a counter offer. So never treat first offer as final. Okay, there are jokes about how 500 ka shirt boys will buy at 500 rupees or 510 rupees on the Instagram or memes. Okay, but yeah, don't treat your first offer as final offer. Okay, then conceding too fast, quick sessions signal your walk away point is close. And yeah, so basically you don't conclude a session too fast. Okay, there happens a lot of back and forth in negotiations, and you do it. Okay, never let emotions drive the room, right? Like I said, if the person is saying 30,000 when you claim 50,000, don't panic. Oh, 30,000, how is it possible? Okay, you don't show your frustration, urgency, or any sorts of emotion, sadness on your face. You hold your calm because you know your partner. Okay, there. um yeah, negotiating hard without crossing the line, right? So what is permissible, what is not permissible, we are reaching the conclusion of the session. So take these points. Okay, permissible, firm anchoring and strategic silence. So you have a firm anchor and you hold silence when there is a counter offer. Okay, then without withholding your own bottom line or partner. Okay, you don't deviate from your partner, never. Okay, you may increase your partner, improve your partner, then emphasizing favorable facts and precedent. Okay, this is permissible, right? You have to tell what the client uh, का के favor में क्या क्या चीजें हैं and how you can make a very good case out of this. That's how the client will get confidence in you, right? So you will emphasize favorable facts, then declining to volunteer weaknesses the other side hasn't asked about, right? Suppose the client has not asked you to go and file before another supplementary forum, but you do it on your own, right? So you don't do it. Like if that client wants you to do it, you charge a fee accordingly. Then is not permissible misstating material facts or law to opposing counsel. Okay, you don't indulge into such malpractices, right? You don't have to conceal facts, you have to be honest and upfront about them. Then settling or compromising without the client's authority. uh, Sometimes some lawyers do get hand in glove with the other side's lawyer or with the other side's client and try to settle the matter or not show their active interest in protecting their client's interest. that you should not never do that. Okay. And suggesting settlement power or instructions you don't have. Okay. So if the client is not willing to settle, you don't portray a picture that you are not allowed to portray. Okay. If a client wants to go through the trial, you go through the trial. You don't try to propose a settlement until authorized by the client. Okay. Coercion threats or misuse of privileged information, you don't do that. Okay. You don't use privileged information against, or you don't let it out in public. That's a privileged information which is only between the client and the advocate. Okay. Then, yeah. So this is my second last slide. And so what all you do before you do build your Vatna, build your Vatna. So you know the best alternative, you know the worst alternative. And you should also research others likely Vatna. Okay. So what that person might propose and what could be their Vatna, so that there is an ambitious but defensible anchor, right? There is a good range that you can play in. Then during a particular negotiation talk, what can you do? You have to build a rapport first. You have to use your rad pack, basically. Okay. You have to ask more than you tell. Okay. Use silence, trade concession, and never give one for free. What you should not give one for free? Never give your um like this thing for free. Okay. Advices, or if something is not asked for, don't do it. Use your silence and don't get too emotional, or yeah, you should basically have a control over your emotions during the negotiation talks. And closing, so you confirm the zopa is real before proposing. Okay. So what there is the zone of possible agreement, you have to confirm that. Now, like the seller was minimum price range was 80 lakhs and the buyer's maximum was 95 lakhs. So you should know the real ZOPA. Okay. And you have to get the agreement in writing before the room breaks up, or an immediate follow-up email, okay, after the session, right? So the last line is, remember, the goal isn't to win the negotiation, it is to get your client the best realistic outcome on paper without a trial. Okay. So this was the session. I open the floor for quick questions and discussions. Yeah, and I will stop presenting my screen. Yeah. Hello all. Was the session useful? Did you learn something new?
Yes, ma'am. Yes, of course.
Yes, ma'am, it was
Yes,
like a
ma'am.
wonderful session.
Wonderful, amazing. So,
Thank you. Yeah, so are there any questions?
Thank you, ma'am.
I would like to ask, like, how can we improve our particular style to give the solutions? Like, I have done 2 or 3 client counseling sessions,
Okay.
but my particular area, I think the solution giving is a little weak for me personally.
See, I would like to know in a more elaborate manner as to what was the client meeting about, because preparing beforehand is very, very important, right? If you are going to deal with a particular case, say a family matter, okay, you need to know what are the possible outcomes, how can a case be framed, right? What are the options available before going to the right forum. So honestly, preparing well before your client meeting is very, very crucial. If you may tell me more about how you faced a difficulty, I'll be able to answer your question in a better manner.
Like, we particularly received the problem 1 hour before, and it was a arbitration problem.
Okay.
So the judges have scored us higher in all the other aspect compared to other panels, but it was just in the solution that we got a little less marks than the other competitors.
Okay, so again, I believe even if the problem was given to you 1 hour prior, had you known more about arbitration, or what solutions you could have given, I think you could have performed better. I understand the constraint of timing, but had you been more prepared about the act and the practical nuances, I think you could have scored better in that regard. Right. So I think preparing in advance is very, very important as lawyers. And in real life, when you go for meetings, honestly, at times it does happen to me too, or many fellow advocates who would agree about the same, that in our profession, every case is different, right? A lot of years of your life, you will find two cases alike, right? In the initial years, plus being first generational lawyers, you will have each case different. Okay. And for each case, you need to know about that particular case. So before the client meeting, at times it does happen to me too that I'm not entirely well versed with what particular outcome is possible. So at that time, you can of course tell the client that let me go through the file, let me go through the papers, so that I can give you a better idea of what all is possible in the case, right? So you don't jump to conclusions, you don't immediately commit or over commit to a client or about what you will deliver, right? You have to take a pause. Whenever you think you're not sure, you take papers, study, go through the act, and then go through what the facts of the matter are, and then you propose what all solution is available.
Okay, ma'am. So, how can we particularly take out more information from the client? Like, they are also guided to not give more of the information.
Okay.
So, what strategies can we use for the same?
Okay, so about that, see, that honestly comes more with experience. So as junior lawyers, there'll always be little trust deficit between the client and the lawyer, because see, of course, if you were a client and you were to give your case to someone, you would also give it to someone who's experienced and not someone who's just a fresh graduate. Okay. So for the client to have that kind of confidence, initial years may you need to know your subject well. When there's a command on your subject and when there is confidence in what you speak with the client, especially practically what happens in the court. Okay, what you read in books is one, what happens in the court is another. Okay, when you intern more, when you have more court visits, when you see what reality is, what practical problems are encountered in court, and when you can tell that to the client will have more confidence in you. But it's just a matter of time, believe me. Initially, this happens to everyone. I was a part of it too. I am a first generation lawyer too. So initially, your first second year of practice, the client will have trust deficit, but eventually when your experience is more, the client will, yeah, share more information and kind of give away the entire file even before you guys have closed the deal.
Okay, thank you so much, ma'am.
You're welcome.
Ma'am, what's your LinkedIn?
LinkedIn advocate Sanskruti Mahale, but I am not very active on my LinkedIn. You can have my email address and email me if you have anything. I'll be happy to help.
Okay, ma'am. Thank you so much.
Welcome. Anything else? Any more questions? Email address. Yeah, I'll type down my email address. Yeah, I have dropped my email address in the chat box. Any advice for one first year law student? Okay, first year law students, please take my advice seriously, that read as much as you can. In a lawyer's life, there is no substitute to reading. You become a lawyer, 5 years, 10 years experienced, or a first year student. Reading has no substitute. Don't run away from it and don't find shortcuts. Don't try to rely on the yellow pages and these things. The more you read, the more seasoned you will be, and you will see, like, you'll see what fruits it will give you only when you enter practice. Okay, Right now, you'll feel, oh, why should I study? I should go and roam around with friends. That is important. But dedicate some time for reading law. Okay. So that will be my very genuine advice, because with time, AI can take a lot of things from you. But if you know your subject well, no amount of AI will be able to replace that kind of practical usage of knowledge. Okay. So read more and more. Read judgments as well. Read bare acts, read judgments. I'll be very happy even if like few people out of the entire batch of 60, 70 follow this. Yeah.
Ma'am, actually, my complete BA this year and starting my law first year. And most important thing, मैं मुझे पूछना था कि मैं ड्राफ्टिंग कब स्टार्ट करूँ अपनी लॉ के साथ या आफ्टर कंप्लीट माय लॉ. सो एक्चुअली माय क्वेश्चन कि मैं हाँ जी.
आपका बीए हो गया है आपने कहा.
Yes, ma'am. Complete my exam this month, July, and I starting my law.
Okay, good.
My first year law starting this year.
Okay, good. So practical tip for you, थोड़ा छोटा छोटा ड्राफ्ट्स देखो, नोटिस कैसे ड्राफ्ट करते हैं. ठीक है.
Okay,
छोटे
okay.
छोटे ड्राफ्ट्स you go through. Of course, you'll not immediately find the real drafts you okay. So you have to go through small drafts here and there. ठीक है. Service agreement हो, NDA हो, या फिर notice हो. You go through such drafts, you'll find the templates online. ठीक है. या फिर while you are interning, I will suggest you to intern. ठीक है. Intern करते वक्त आप जो भी पढ़ो, try to draft it, and if you don't want to type it, try to write it. You will memorize that draft in a much better manner. ठीक है. So start with small drafts. Even if you just know what are the important clauses and what clauses are not to be included, you will still be in a better position in real life while making a draft.
Yes, ma'am. But my father tell me कि actually my relative as a lawyer, as a advocate in the court, high court, supreme court, and district court, whatever. And my relative are trained me in law industry. कि मेरे father कहते हैं suggest me कि you join your cousin brother. Actually, my cousin brother always complete BB, LLB, and LLM in the like. Indraprasth University, Delhi. So
Okay.
yes, yeah.
Yeah, you can join them. There's no problem in joining someone, because that will only help you know the practical nuances. And if someone is experienced and there to guide you, you can take that guidance. But don't stop working on yourself. Right? You
Yes.
go to the office, you attend the court, but at the same time you do your work. You draft, you read. Okay.
Yes.
Yeah.
Okay. Thank you.
Okay. What about moot courts, ma'am? Yes, you can do moot courts. Moot courts give you good background as to how a real court happens, and the national bail advocacy competition. You all, I think, I don't know how many of you all have registered, but it's a good competition, and TCC is really doing a great job in providing such platform for the first generational lawyers. Ma'am, can you tell us which semester we should do the internship? The sooner the better. My honest answer would be the sooner the better. And if you have connections, there is no shame in using connections. If your parents can help you get an internship, get it. You have to make fruitful use of it. That's it. Okay. Nobody is giving you any award for suffering and trying to do it all alone. If you have connections, use those connections, get placed at a good place, but make fruitful use of it. Yeah, Ramanshu Verma, please ask me a question.
Good evening, ma'am. My name is Ramanshu, and first thing, I wanted to ask is that which internship is better, the offline mode or the online mode?
Definitely an offline internship is better. But if you are unable to find an offline internship, you can do an online internship meanwhile. But I'd suggest that, as students, you guys can still like you are unable to figure out whether to land up in a corporate job, whether to do litigation, whether to give exams, right? Your internships is the best way for you to navigate as to what you really like. So I will suggest try doing internships at different places. Try a law firm, try an individual litigant, try doing a corporate job or corporate internship, right? So that you know what is your liking and what you would like to follow after you graduate. So that's about internship. Did I address your question? You had something. Yeah, online versus offline. Yeah, try doing offline internship. But if you can't find an offline one, you can always go ahead with the online till then. Ma'am, you.
Ma'am, like right now,
Yeah.
I'm in like my second year. I've completed my second year and
Okay.
moving on to the third year.
Okay.
And the basic platform for accessing these internships, like the information where from which we get these, from like which internship to actually go through
Yeah.
do is Logtopus or Internshala or Lawbhumi. But these sites, whatever the information is there,
Yeah.
it is always there for either they for off either for the paid like the first thing which we as interns are looking for is like a bit of paid internship. As a third year student, I am also looking for a paid internship, but they don't provide paid internships for fourth like third year. Paid internships basically start from fourth year and fifth year. The second condition or the problem which I face is that as a second year law student,
Mm-hmm.
third year rather, uh, I do not want to go out of my city, but the thing is that I only am able to get these online internships only as a option, because since I cannot go outside and much of the offline internships require presence and they are either in Delhi or Bangalore or Mumbai,
Which
so
city
it
are you
doesn't. Ma'am, right now I'm in Lucknow,
in?
and so
Okay.
like there aren't many offline good offline internships there. Just those government offices like Lokayukt or Lok Adalats. So I mean that is good for a certificate, but like experience, I'm not very happy with that. Because we are not able to learn that much of things
Okay,
that we
very
can actually
honest
learn.
answer to your question. Very, very honest answer to your question. Uh, Talking about paid internships, it is difficult to even find paid jobs as juniors. That is the reality of litigation. Sorry to say, but there are juniors who will graduate and still not get paid by their seniors under the garb that we are paying you an experience. Okay, so that is the reality. And somewhere like I said earlier, time is the test. You have to let that time pass for you to start earning. Okay. Till then, you will have to consider it as a learning and less in terms of how much money you are getting. I understand this concern in entirety that you also want some pay for the work that you are putting in. That is a very fair ask. But currently, our profession is not very well incorporative of that request. Okay. With regards to you telling me that there are not much good offline internships, the problem with offline internships is many of the juniors will only intern for 1 month, maximum of 1 month, 1.5 month, and then they leave the internship. You cannot learn anything in 1 month. Try getting long-term internships. Try associating yourself with one particular law office or a senior, okay, for 6 months, 1 year. After your college hours, you go there, work. Bet on it, you will learn a lot. But if you try to hop on between places for 1 month, you'll never be able to learn the kind of knowledge that you are expecting from the internship, right? So you will have to do that. I hope
Uh,
that answers your question.
yes,
Mhm.
ma'am. And can I ask one more question if
Yeah,
that's
yeah.
fine?
Go ahead, go ahead, go ahead.
Ma'am, actually, as a budding lawyer, the first thing which we should incorporate is confidence, because without confidence we cannot present the facts in the courtroom. But
Correct.
the point or the situation which happens with me is that though I love law as a subject and I love all the statutes, and I'm also a good orator. But the problem is that as soon as I hear like that, though, and also I've attended moot courts and moot competitions, and I've won them. But still, as soon like nowadays, what is happening that whenever I'm hearing these terms like moot courts or bail at any competition regarding to law, I get
Yeah.
nervous, and I try to make a distance between myself and that competition, and rather try to avoid that. But that isn't the solution. So can you just suggest some ways through which I can
Yes,
increase my confidence and try to like stop
I'll do it.
avoiding these things?
I'll do
Thank you,
it.
ma'am.
I am very happy with your question, first thing first, because it is a very genuine question. And when you fear something, you try to run away from it. That is a normal human psyche, and it's absolutely normal. You are just very gutsy to ask this question, but this would be a problem for many. So this solution might sound a little boring, but it helps. So number one, try deep breathing, try box breathing. It helps. Your palpitation, your nervousness calms down when you do breathing, okay? Deep breathing. Plus, sadly, our profession is such, okay? I'm not at all demeaning this profession, but it is such wherein you require a lot of mental strength, okay? And for mental strength, you will require tricks wherein you can keep that mental composure. So one is you should do deep breathing. Okay. Few of you guys will think this is a very outdated advice, but it helps you try it. Number two, while you are telling me, Ramanshu, that while appearing before the forums or competitions, you feel nervousness, I suggest you practice whatever you want to say to the judge before the mirror, okay? And try as though, like, look at yourself, record yourself, or look at yourself and say whatever you have to say. When you do this exercise, you'll be much more confident. You'll know how you are speaking. You'll also know what your body language is, what your voice modulation is, whether you are too fast while you are speaking, while you are nervous. So if you do this exercise in front of the mirror before appearing for the real competition, you'll be in a much better position on the day you do it. And before you do it on the day, you also do deep breathing so that you are calm. And since you've done it previously, you know what mistakes you are making. So you might be talking very quickly or very fast because you are nervous. But when you practice this earlier before the mirror, you will know where all you can improve. Okay. So try doing it next time and let me know if that helps.
Thank you so much, ma'am.
Welcome. Yeah, Ritesh Sharma and Nascent Morimo. Quick questions. Tell me quickly. Ritesh, you start.
Ma'am, I ask you question, same question I yesterday telling with sir. Actually, I confirm which country is the best in master in law and with PhD. Actually, I chose the European country like Spain. Actually, I improving my English with Spanish. After complete my English, I focus basic Spanish language, alphabet in Spanish, and which country are best in law in Europe. Actually, telling me many people are many
Ritesh,
lawyers
this
and
is
many
Ritesh.
my
Sorry to break you in between, but I am not very well versed with your question, with the answer for your question. So honestly, I'm not the best person to advise you on this question. If there's anything else, please type it in the chat box. I'm not very much aware about which country can help you, right? So yeah, like take it from somebody who knows about that topic. Yeah, Nasrin Morimut, please go ahead with your question.
Okay, so ma'am, I'm a first year law student. I'm going to start my career in law from this year. I'm just want few advices for mod court. I'm planning to attend them as a first year. Is it okay to attend in first year or not? I want to participate in all competition as much I can.
I didn't get what you are saying. What are you trying for?
This is okay. Sorry,
Yeah.
I'm trying to attend mod court. I'm a
Attend
new law
court.
student.
Is that what you say?
Yes,
Okay. So as a first year student, are you asking me that as a first year student, is it a good time to start moot court? Is it?
yes, and
And Okay, that's it. The question is just that, right? Whether first year is a good time to start moot court, the sooner the better. Internship, sooner the better. The more you practice all these things, it will help you in real life when you come to litigation as a profession or as a lawyer out in the market. So the sooner the better. Internships, moot courts, reading, judgment, drafting, everything. Sooner the better. Okay, anything else? Quick, I have a meeting, so I am already late for that. If we are done,
Thank you, ma'am.
most welcome.
Have a nice day. Have a great day.
Thank you all. Can you all switch on your cameras for a quick photo? Would like to see all your faces, pretty faces. Okay, sorry. Okay, no problem. Yeah, and Anuradha, I'm sorry I've missed your question. Anuradha, you are telling me due to health